Good morning, everyone, and welcome to day 3 of the second ASEAN Environmental Law Conference. I am Bryony Eales, the moderator of this opening session. So we are delighted this morning to have opening remarks from Damien Eastman, Deputy General Counsel of the Asian Development Bank. Damien joined ADB in 2014 as Assistant General Counsel for Institutional and Administrative Affairs. Prior to ADB, he spent over a decade at the IMF and established corporate and commercial, had a specialized corporate and commercial litigation in private practice as well. We are so delighted that he can join us. So after Damien's remarks, Damien will also welcome our other guest who will provide our keynote address, who is Justice Ayesha Malik of the Supreme Court of Pakistan. Justice Malik has written a number of incredibly important environmental law decisions. So we're in very capable hands with our opening. Damien Eastman, the floor is yours. Welcome.
Thank you, Bryony. Honourable Justices, distinguished speakers, ladies and gentlemen, a very warm hello this morning from ADB headquarters here in the Philippines. I'm truly delighted to welcome you here today and wish to thank you for joining the ADB, the UN Environment Programme, the Asian Research Institute on Environmental Law, the USAID Demand for Wildlife, as we host these 3 important dialogues. Today's discussion will focus on judicial remedies in climate change and environmental law, and will offer insights on best practices for strengthening the capacity of environment courts to uphold the rule of law. Now, as we gather here today, there's never been a more critical time to discuss judicial remedies in environmental and climate change law. Earth's many environmental, climate, and social challenges are driving increasing numbers of citizens to courts to seek environmental or climate justice. Now, I'm sure many of you attending today will appreciate that judges do have a very challenging role in navigating fair, timely, and sustainable remedies within their existing and sometimes outdated legal systems. But with recent developments in environmental and climate change science, it's become apparent that financial penalties alone for environmental degradation and climate change are often inadequate. And this is because monetary awards simply can't compensate for the replacement of precious ecosystems. And even though court orders requiring the restoration of the environment are critical, courts also need experts to guide them through the necessary action and costs of that restoration. So when it comes to climate change, judges have to navigate many technical issues, including the complex and difficult issues around attribution. Courts are keenly aware that when it comes to climate change, prevention isn't just better than the cure, it's actually a matter of survival. So although we have a long road to travel, we are in the decade of action, which means making good on cutting global emissions in half by 2030 and scaling up finance for adaptation and resilience. Judges are keenly aware of their role in national environmental and climate change governance. We sincerely hope that today's discussions about remedies and best practices support you judges in your daily work. Now, ADB is also doing its part. By 2030, 75% of ADB's operations will fund climate action, and climate finance from ADB's resources is targeted to reach 100 billion on a cumulative basis. We will also continue to support the judiciaries of Asia and the Pacific. And in this regard, in 2021, ADB's Office of the General Counsel launched the next phase of our judicial capacity building program, which is aimed at providing sustained support to judiciaries in adjudicating environmental and climate change disputes. Initiatives under this assistance project will include tailored capacity building training programs, specialized knowledge resources, and support for knowledge sharing events, such as the second ASEAN Environmental Law Conference. Our work creates linkages amongst courts in the Asia and the Pacific, along with courts worldwide through the Global Justice Initiative for the Environment and other partners. We also recognize the convergence of environmental, climate change, and commercial issues, and our new phase includes a commercial component. ADB is also delighted to have the opportunity to support the Council of ASEAN Chief Justices with its judicial education and training program. Indeed, it's ADB's goal to support judicial networking in the Asia and the Pacific region, which underpins our concept for the Judicial Masterclass series, which we are launching later today with our partners from UNEP and USAID Reducing Demand for Wildlife. These masterclasses will allow judges to workshop the outcomes of seminal regional jurisprudence in small group settings using virtual platforms. We are truly delighted to be supporting the judiciaries of Asia and the Pacific through these initiatives, and we really look forward to working with you. So let me conclude my remarks by welcoming the Honourable Justice Aisha Malik of the Supreme Court of Pakistan to the floor for her keynote address. We are deeply honoured that Justice Malik could join this event. She's the first female judge of the Supreme Court of Pakistan and has written several keynote decisions on environmental justice. In the Imrana Tiwana case, Justice Malik was a member of the bench that stressed that public participation in environmental impact assessments is essential because such participation clarified and equates to environmental democracy. In the Muhammad Ayers case, Justice Malik held that precautionary measures are central to upholding environmental justice, where there is a risk of irreversible harm to the environment. Justice Malik, I warmly and sincerely congratulate you on your recent appointment to the Supreme Court of Pakistan. The floor is yours.
Good morning. It is a great pleasure that I join you today at this second ASEAN Environmental Law Conference, Transforming Principles into Practice, supported by the Asian Research Institute for Environmental Law, ADB, UNEP, USAID, and I'm told over 26 organizations in the Asia-Pacific region. I would also like to thank the conference committee for providing me the opportunity to participate and share Pakistan's response to preserving the environment and climate change. Over the past 2 years, with COVID-19 and lockdowns, we are reminded of our vulnerabilities, of the imbalances, and as a consequence, we must reset our priorities with the environment and climate change at the top of the list. One of the biggest concerns is to awaken the realization and to admit and acknowledge that the environment needs protection amongst the masses. For this, there must be an adequate effort by the government to create laws and policy which address this concern and at the same time creates public awareness and encourages public cooperation. Also required is for the strong regulatory framework which navigates rights and balances rights, allowing development and industry to coexist with the environment to also create public participation and public awareness. For the system to work, an effective policing mechanism is needed to ensure that rules, laws, regulations, and policies are followed and that violations and breaches are responded to swiftly. So what I'm saying is nothing but the obvious, that a strong environmental legal framework is required to protect and restore the environment, a lot of which rests on the public being conscious, aware, and knowledgeable of its rights and responsibilities. The fact that we need to discuss the journey from principles to practical approaches means that this ideal situation does not exist. While we come from different jurisdictions with different legal frameworks, the issues are similar, and by sharing our experiences, we can help each other move together in order to combat the imminent threat towards the environment and to deal with climate change. So let me share with you Pakistan's experience. Pakistan faces multiple climate change and environmental challenges. With its fast-growing population of almost 221 million, the issues related to conservation and depletion of natural resources are of grave concern, especially water shortage. Pakistan is also vulnerable to the effects of climate change, with torrential rain, monsoon increasing, and rising temperatures, which have had a negative impact on agriculture. And please remember that agriculture is a vital source of the economy for Pakistan, which contributes significantly to the GDP, labor force, and foreign exchange. Another serious issue is the dense smog, which has totally polluted the air quality and has choked normal living. In fact, air quality pollution has become such a major issue for cities like Lahore that they have become and are listed as one of the most polluted cities in the world. So the journey ahead is long and challenging. And while systems and legal regimes have been in place, they have not been as responsive as required. So it is the courts which have had to step up, fill in the gaps, and have played a significant role in bringing environmental rights, environmental justice, and now climate justice to the forefront. This is especially true in countries where situations and adverse impacts are not as evident and as material as they should be. So they're not easily anticipated by the regulator, by the legislator. However, when matters are brought to the court, the rights tend to evolve and the remedies along with it. The scheme of law in Pakistan is that we have a constitution which does not declare any right to the environment, nor do the principles of policy. There is a regulatory framework provided for under the Pakistan Environment Protection Act, which initially was a federal law but has now become a provincial law. That is, all the provinces have adopted and introduced their own environment-specific legislation. This legislation has established a regulator, that is the Environment Protection Agency, and also has established environment tribunals and environment magistrates. It uses tools such as the initial environment examination report, as well as the environment impact assessment report, as well as the environment protection order, in order to balance the values between the rights of the people and the environment. However, it is the courts which have always declared the rights of the environment and have played a significant role in bringing the issues concerning the environment to the forefront. What started off with the Sheila Zia case back in 1994, it was for the first time that the Supreme Court of Pakistan declared the right to a healthy environment as part of the fundamental right to life and the fundamental right to dignity provided in the Constitution. The court also introduced the precautionary principle with specific reference to international documents such as the Rio Declaration on Environment and Development into the Pakistani jurisprudence. Moving on, in a mining case, the Quera mining case, the Supreme Court declared the right to unpolluted water as the right of every citizen wherever they live, every person rather, wherever they live. In dealing with noise pollution, the Supreme Court declared in another case that even though one is carrying out lawful trade, it cannot be injurious to others if the comfort of the community is affected and it becomes a public nuisance. In another suo moto case, suo moto being a power that the court exercised where it feels it's absolutely necessary to interfere, the Supreme Court restrained a housing scheme which would have had a direct and adverse bearing on the Margala Hills because it would amount to cutting down the forest. And therefore, this court declared the right to an ecosystem that needs to be protected. The Supreme Court has also taken note of the process of deforestation in the hills, Margala Hills and the Murray Hills, and has disbanded any projects on those hills, saying that there was no possibility of revival of such projects when they affect the ecology so much that they would affect future generations. So in fact, the Supreme Court once again declared the rights not only to protect the rights of the present generation, but also of future generations. In the same way, the High Court has also played a role where the High Court has also declared rights related to climate change policy, making that a declaration that the government take a more efficient and effective response to these climate changes. Recently, the High Court has declared the right to climate change policy which requires a more responsible response from the government, saying that this is on behalf of the future generation. So a group of women came to the court to say that the government was not taking enough notice of the problems of climate change, and nor was it effectively implementing its policy, hence the ruling by the court. The court has also recognized international principles in helping declare rights and remedies where matters have come before it regarding the environment. So in a case regarding canal road expansion, the court recognized and applied the public trust doctrine, holding that a green belt on both sides of the canal road in Lahore was a public trust resource and could not be converted into any private use or any other use. It allowed the widening of the road in such a way that the public area was preserved and protected on the basis of and while applying the public trust doctrine. The courts have recognized that there are multiple stresses on the environment, and sometimes it is not possible to redress all the issues. But nonetheless, a perfect environment is only maintained if it is a balanced environment where businesses and rights and development their values are balanced in order to ensure that the environment is preserved for future generations. In a well-known case known as the Imrana Tiwana case, the project, which was basically developing a road which was more than 7 kilometers long, known as the signal-free high-speed expressway, was challenged before the court. I was a member of the bench as well. And at that time, the High Court decided that while they cannot look at whether the road should be built or should not be built, because that may be a policy decision, what it can do is examine the manner in which the regulator has carried out its statutory functions. So the court recognized the principle of environmental justice and stated that the same was vested in the right to life, and that these constitutional principles of democracy, equality, social, economic, and political justice have to be seen with the environment lens as well. It stated that the corpus of international laws have the purpose of protecting life and nature, and this included environmental principles of sustainable development, precautionary principle, intergenerational equity, and the public trust doctrine. The court recognized that by looking into the manner in which the environment assessment reports were made, the court could actually determine whether or not the regulator had done its job and had actually taken measures to protect the environment. In this case, it was concluded that in fact the regulator did not do its job and did not keep the environment did not keep the interest of the environment as in the forefront the way it should have done so. Similarly, in another case which involved cement factories, the court again looked at sustainable development and declared that the principles on which sustainable development hinged upon should be looked into by the courts in order to ensure that the regulator was integrating environmental considerations, economic considerations, development plans, projects, and programs. So it recognized the precautionary principle once again, and the court once again declared that such projects cannot be developed or expanded at the expense of the environment. Another tool used by the courts is by declaring procedural rights. In a case which concerned the development of a huge shopping plaza as well as an IMAX cinema, the Supreme Court considered the public trust doctrine and said that a public parking and shopping mall, without observing all courtal formalities, without the regulator fulfilling all its regulatory responsibilities, was grossly illegal and offended the Basic Act. Again, in the signal-free corridor case, the Imrana Tiwana case, the court explained that the environment impact assessment was nature's first man-made checkpost. Nothing adverse to the environment would be allowed to pass through it, and that courts could review the assessment report to ensure that the rights of the public were protected, that environment considerations were given due recognition while formulating while going through the relevant factors of the project, and to determine whether ultimately life, health, dignity, and the well-being of the people was kept in mind. In a judgment that I considered as well, called the Muhammad Ayaz case, the Environment Protection Agency and its power to seal a plant were under review. And the court basically considered that this power is the power to seal a plant is an enabling provision which ensures compliance with the EPOs that are issued by the regulator and allows them to take immediate steps that are required in order to prevent any further harm to the environment. In another case that I was hearing before I was appointed to the Supreme Court, I initiated a public-private relationship between members of the public and the government so as to ensure that people got clean drinking water. The petitioners that came to court were from an area where they claimed that they were not getting clean drinking water. The government stated that while they were in the process of ensuring that clean drinking water was available to everyone, this was part of a program which would take at least 5 years. So the issue was that what were the petitioners supposed to do for 5 years? So the concept of a public-private partnership was introduced. Members of the public community were asked if they would be willing to contribute for some interim measures with the government financially. They agreed, and so small tube wells and a water boring system was introduced. And the petition was ultimately disposed of with the government saying that they were able to successfully implement this plan in several districts and were able to ensure that those areas all got clean drinking water. So again, with a little help and a nudge from the public as well as with the government, they immediately got clean drinking water. Another tool that the courts have used is the establishment and constitutions of commissions. So the commission works as a fact-finding body which builds consensus and finds solutions and at times even recommends legislation. A petition which challenged air quality required that the court required that a commission be formed, which was going to check on vehicular air pollution, and it was going to provide with feasible, practical solutions while monitoring and controlling the air quality so that it could be seen what and where and when the air quality problems were arising. In another case, the Asghar Laghari case, which is one of the first climate change cases from the Lahore High Court, a farmer challenged the inaction of the government with respect to climate change, its policy of 2012, and the law that it had made. And so the commission was tasked to consider all the factors and to determine what was causing the delay, and then to provide some sort of cross-sectoral solution so as to encourage and ensure that the government was able to respond to the issues of climate change and to issue the climate change as well as to monitor climate changes. In another case which concerned the preservation of birds which are now going extinct, a commission was again tasked to assess whether the hunting of these birds was a sustainable activity. So with the help of commissions, the court is able to get information, data, solutions, as well as at times encourage public participation, and so get the opinion of the public as well, and therefore use all that information to encourage the government to either legislate or make policy, or at least find a solution to the issues that are there. Another area that courts have often looked into and that I have also relied upon is lawmaking and policy making. So now, while judges are not in the business of making laws and policies, what they can do is encourage the government to make laws and policies. So in a case involving, the issue was dog culling, and the petitioner's case was that people were randomly, which included the government, was randomly killing dogs and not disposing of the carcass in an appropriate manner. I heard the case for over a year. It took that much time to encourage the government to devise a policy which was based on international practices on dog culling. And now that policy has been formulated. It is the first of its kind in Pakistan, and it has been adopted by the government of Punjab. So this is a way where you encourage the government to do what it's required to do with public participation. So not only did the policy provide for means and ways to avoid killing dogs, but also provided for a manner to dispose of the carcass in the event that it was absolutely necessary. In another case, which involves brick kilns, because they are considered to be part of the problem of smog, again, the high courts encourage the government to devise a policy or a law which would control the issues related to brick kilns and the kind of technology that is required for the funnel, so that the smog or the smoke that comes out ultimately does not damage the environment. Another tool that is used by the courts is known as an implementation bench. So once sometimes a policy has been made in place, or directions have been given, legislation has been made in place, a commission has been made, the court then goes on to an implementation bench, which then just gets follow-up reports to see whether in fact the work that is required to be done is being done in accordance with the directions that are being given. So recently at the Supreme Court, I've been part of an implementation bench, which is looking at the issue of deforestation in Sindh. And the objective of this bench is really to see what is the present position, what have been the orders of the court, and to ensure that the government is following out on the orders that have been given, and that while hearing the petitioners as well as the government, as well as the relevant stakeholders, directions are then given to ensure that work progresses, and ultimately the objective is to ensure deforestation. So these are some of the tools that the High Court and the Supreme Court of Pakistan, the High Courts of Pakistan, have used while exercising their power of judicial review. And these tools have not only effectively helped to declare environment rights as fundamental rights, but have declared certain procedural rights as fundamental as well, so as to ensure that the environment is heard and responded to. Developing the public-private partnership, forming commissions, encouraging lawmaking, policy making, and working through an implementation bench also ensures that things are done on a more continuous basis. Moving forward, in a more recent case, the High Court of Sindh, while it pronounced the right to environment over an area which was encroached, and said that yes, the citizens have a right to this green belt not being encroached, it also imposed the duty on the citizens to say that this right was not an absolute right. It came with certain duties, and it was the duty of the citizens to ensure that the green belt remained clean, that its footpaths and boundary walls were neatly developed, and that it should be maintained at a reasonable civic standard. So in fact, the court recognized the petitioner's claim that there should be a green belt, but imposed a responsibility on the society, on people. And this is what I said initially, that public awareness, public involvement is necessary if we hope to achieve anything close to protecting the environment, as well as looking at climate change. I think it's important to also mention the role of tribunals, which is another specialized forum, and probably a more effective and efficient forum, which specializes in protecting the rights of complainants who come to the tribunals claiming that there are environmental issues. So while we have environment tribunals, they don't I wouldn't say that they have been the most responsive, and they don't have that much visibility in the kind of work that they've done compared with the High Court and Supreme Court. Nonetheless, some of their efforts do require recognition. So while in recognizing the polluter pay concept, a tribunal in Punjab required a plant to set up an air monitoring device so as to ensure that whatever emissions the factory was making could be regularly monitored by the EPA, the regulator. And this was by invoking the polluter pay principle. In another case, a tribunal in Sindh directed that there should be pre-trial negotiations, and that pre-trial negotiations would help resolve environment disputes quicker, effectively, with the participation of the public. So the tribunal said that they would carry out pre-trial negotiations in order to have effective environment-friendly results. Tribunals have also played a role in looking at scientific and technical data that is placed before them by the regulator, because tribunals are composed of one member legal and two other members who are not law specialists, but can be finance specialists, environment specialists, depending on their appointment. So in a case that had to do with tire burning, while the regulator did not allow permission on looking at the information and the data provided, the tribunal said that in fact the plant had gone to the trouble of getting state-of-the-art machinery as per international standards, and these are all the required equipment and machinery that is required to mitigate measures to ensure a more sustainable green solution. So it then directed the regulator to look and once again go through the machines and the processes of the factory to ensure that the standards by the Basel Convention and WTO are maintained. So what we see with the tribunal now is that from simply criminalizing environmental breaches, they are working towards restorative and remedies which require a more creative solution. So the tribunals have also imposed fines and then use that money to rebuild the environment in some cases. However, we do have a long way to go. And if we want to preserve our environment, particularly in cases and situations where we see that the law doesn't exactly get the results that it should have, then judges do have to craft and create solutions within the framework of the law. My own experience on the bench over the last 10 years has shown me that this is very possible and doable, so long as you are conscious of the fact that the environment is there, that the environment needs to be heard and represented, even if it is not through any party, but we must all wear the green lens to ensure that we are conscious of the fact that we must preserve and protect the environment. On this note, I wish you all a very happy conference, and I hope that you achieve good results in doing so. Thank you.
Many thanks, Justice Aisha Malik, and also to Damien Eastman. We very much appreciate your comments. And what I should have said at the outset of today's session is that today is a special day designed for judges, but environmental lawyers and climate lawyers are very welcome to join all sessions today, of course. And there is a focus today on judicial remedies, both environmental law and climate change law. We are facing unprecedented challenges. Those challenges are complex. There are multiple stakeholders and the problems are changing quickly. 21st century problems need 21st century challenges. And as Justice Malik stressed, judges are often now faced with having to craft and create solutions within the law to these new challenges, and that it is really important when matters come to court, when you are arguing a matter, when you are presiding over a matter, to wear a green lens and to bear in mind all of the different implications. So with that, I welcome you, a very warm welcome to day 3. The next session is session 7, and we should start that immediately because we are now running a little behind time. So please now sign out and sign back into session 7, and we will see you there. Thank you very much.